Welcome back to the Gary Sutton Show on WSBA. Everybody was talking yesterday about the Hobby Lobby case, and also part of that case was Conestoga Wood Specialties. With us this morning is one of the lawyers who was involved in the case, and we're talking about Randy Wenger, who is a lawyer on the Conestoga Wood Specialties. He's with the Pennsylvania Family Institute, and he joins us here this morning. Randy, it's great to have you back on the show. Good morning to you.
Good morning. Thanks for having me.
Randy, I guess you would say you're feeling fairly satisfied today. What was the ruling what you had wanted? Did you get the total thing that you were looking for out of it?
Oh, we got a great opinion written by Justice Alito, and he's been a champion of religious liberty when he was on the Third Circuit, and is now showing him to be a champion of liberty and on the United States Supreme Court as well. So we are very pleased.
I am seeing all kinds of what I would say wild reactions by people all over the country. I'm sure you've seen many of the same things and watching the news and so forth. What were your reactions when you heard people say, well, you're taking away the rights of women, this is an attack on women again? I know a lot of it's political, and yet at the same time, there are people listening out there to this kind of stuff. And, what do you make of it?
Yeah. I think people don't really understand what the problem is here in the first place. If it were not for the Obama administration inserting business into this mandate to begin with, we wouldn't have this problem. The way that we've dealt with contraception in the past has been protect people's access, but don't make other people complicit in it if those others are opposed to it. But it's only because we had the government coming and inserting itself in the process by forcing employers basically to fund a mandate that they didn't want to fund themselves. So if anybody's complaining about employer making choices about contraception, well, let's remember that access still exists. But the reason we've got a problem is because the government is inserting business there where it doesn't belong.
It's interesting when you look at how the five justices, and of course we had 5 conservative justices here and 4 liberals voted against, which again, I have a problem with when it comes to the Supreme Court. But by the same token, all 5 conservative justices appointed by Republican presidents ruled in favor of closely held for-profit businesses, those with at least 50% of stock held by 5 or fewer people, such as family-owned businesses, which you represented in this case with Conestoga Wood Specialties, in which the owners have clear religious beliefs. And both the corporations involved in yesterday's ruling, Conestoga Wood Specialties of Pennsylvania and Hobby Lobby, which is out of Oklahoma, emphasize their conscientious desire to operate in harmony with principles they believe in, which happen to be biblical, while competing in a secular marketplace. And that has been a problem for us, has it not, in the past?
Well, it has, but not like it's been most recently.
Right.
It's interesting when you look back in case law. We've had plenty of cases through the years dealing with religious liberty issues, but we haven't had a lot of cases dealing with for-profit businesses. And I think the reason for that is government has been growing, and government has been inserting itself in more and more things, and then taking positions now that are directly contrary to, I would say, a large portion of America's populace. And so when they came up with this HHS mandate, you look through the record that was developed, and the government acknowledges that they knew that there was going to be a religious liberty problem for some religious employers, and yet they pushed ahead this particular mandate. They would not have needed to do it, but it was as if they were choosing to pick a fight over religion. And I think we're going to see that more and more, which is why I think it's increasingly important that the court speaks like it did yesterday to say, yeah, in the 21st century, you don't have religious liberty any less than you have over the prior 200 years. And of course, it extends to people who are operating businesses. We're not going to whittle away the Constitution piece by piece.
Of course, they said yesterday closely owned businesses, and again, we defined what that was a moment ago. And we look at those because I know a lot of people out there are worried and saying, well, then any business can come out and say they can do this. But that's not the case. These are families which have practiced their religion and business, and by the way, have been very, very good with their employees over the years, been very generous with their employees over the year, but have a track record of this is not Johnny-come-lately to religion. This is the way they have practiced for a long period of time, right?
Well, yeah, that's absolutely true. And in fact, long before the Affordable Care Act, they were out there giving insurance coverage that was far beyond what they needed to. as far as preventative care coverage because they care about their employees and want to keep them healthy. They genuinely care about them, and then government inserted itself here and said, oh, you need to do this piece too, and by the way, if you don't, we're going to fine you $100 per employee per day, so $36,000 per employee per year if you don't do this tiny little piece of the coverage. But if you drop insurance altogether, we'll just fine you $2,000 per year rather than $36,000 per year per employee. And you look at that and think, what in the world is going on here other than picking a fight and making it impossible for those who they know are going to have a religious objection to this to run into a problem.
And it was not like these two companies and joined together on this were saying we're not going along with any of this. It was there were 20 different, I guess, and I hope I'm saying this correctly, mandates that were there, and they said there are 4 that we really don't like. For example, if you say we have to provide coverage for contraceptives like the morning after pill, for us, that is considered tantamount to abortion. So it wasn't like they said all these different 20 we're going to oppose. We're opposing only 4 while taking care of paying for 20 for our employees, and we have been paying for them for a long period of time, as I think you mentioned earlier.
Yeah, well, in the past they weren't paying for contraception because that's not something that they thought was core to preventing diseases. I mean, after all, when the Affordable Care Act was passed, this provision has to do with prevention, disease prevention. And so it's kind of funny that we're ending up with pregnancy prevention, or probably more accurately, life termination as part of a theoretically preventative health care coverage. But yeah, my clients aren't saying we're opposed to the entire Affordable Care Act or even the entire contraception mandate, but that contraception that could result in the death of a new human life.
You know, I was interested in this when I was looking at some of the emails that I had, and I asked what people thought about it yesterday. And a woman wrote in, said that this was in a tweet rather, she said, the men still think they have the right to make decisions about women's reproduction. This is not men making the decision about women's reproduction. There's nothing that says here these women cannot get coverage, right, in this decision anywhere that I can see.
Oh, yeah, that's absolutely right. I mean, first off, there are women involved in these businesses. Elizabeth Hahn, for instance, was one of the plaintiffs on behalf of Conestoga Wood Specialties. She, of course, is a woman, and she's not making a choice on people's reproductive health care. At the end of the day, the compromise has always been people can choose their own contraception. Nothing has changed about the Griswold decision back in the late 1960s. That decision still stands. The question is, are we going to force somebody else to pay for your contraception, particularly when that somebody else has a religious objection to it? So it's not at all about access, and the court was fairly clear that even if you're looking for access, you don't have to have the government come in and mandate that somebody who has a religious objection to it has to be the one to cover it.
Yeah, I mean, therein, to me, lies the larger question about, okay, we all pay for things in our society that we don't necessarily like. You know, and I said this morning to somebody, an example would be we might pay for more welfare than we would like to have to pay for as citizens, and yet we are all kind of tied into that by our taxes and the money that is confiscated from us. Yet at some point in time, there comes a point where conscience and religion do enter the fray here. And I know the Religious Freedom Restoration Act was big in this, a 1994 federal law known as the Religious Freedom Restoration Act, which was also kind of involved in this. Talk a little bit about that involvement and the idea of where is the dividing point that we say, okay, there's a ceiling that I won't go past, and obviously in this case, Conestoga Wood Specialties and Hobby Lobby would not go past it.
Yeah, the Religious Freedom Restoration Act was passed by Congress because the court itself started getting antsy about the breadth of our First Amendment and the religious freedom protections that were in there. And so historically in our country, we've applied what's called strict scrutiny. If there's a law out there that is burdening your religious exercise, then that law can only apply to you to the extent that the government can show a compelling government interest, like the kind of interest where the government would say the world is going to be turned upside down if we allow these people to opt out. And and even when there's a compelling government interest at stake, to say the government's acting in the least restrictive means. In other words, not hurting religious liberty any more than it needs to. Well, the Supreme Court, in a case dealing with drug use, where there were some federal drug enforcement agents who were part of a Native American religion,
right, where
smoking peyote was part of their religion, and the court at that point just threw up its hands and said, okay, when you have a neutral law that's not directly targeting religion, we're not going to apply strict scrutiny anymore. Well, that really undermined the protections that we've had in our Constitution. So Congress, up in arms, as rightly they should have been, passed the Religious Freedom Restoration Act because they wanted to restore the test that had historically been used to protect our religious exercise. And that is precisely what they did, precisely what we brought our claim under, both the First Amendment itself and under the Religious Freedom Restoration Act. And that gave the protection here to Conestoga Wood, to the Hahn family, to the Greens and Hobby Lobby. But more importantly, it gives protection to all the rest of us, because regardless of where we may be on conscientious objection to abortifacients, it's a completely different. There are completely different issues down the road that we all need to face. And if we don't protect religious liberty here, where's religious liberty going to be protected down the road for others who need it? So this case now is making clear that you don't give up your religious liberty simply because you're a business owner running a business. So
Randy,
we're thankful for this, not just for the Hahns, but for everybody's religious liberty.
Yeah, and it still means something here in this country. I think that's what is part of the lesson out of this. Randy, thank you so much for your time with us this morning. We truly appreciate it.
Thank you.
And you take care. Randy Wenger with us this morning, a lawyer in this case for Conestoga Wood Specialties and also the Pennsylvania Family Institute.